Third case on this morning's docket, case number 110095, May v. Klein.
Your Honor, I'd like to reserve 5 minutes for rebuttal, please.
5 minutes is granted.
Sean Lutz appearing on behalf of William May, petitioner, appellee. The facts on this case is on November 9th of 2012, Mr. May was involved in a fight at the Larned Correctional Facility with another inmate named Dale. This fight was observed in part by a correctional officer. In his report, the correctional officer said that he observed two inmates fighting. He yelled several times for them to break up. They continued fighting. He stated that inmate Dale appeared to be the aggressor. He yelled at them again, and they did not separate. He pepper sprayed them 3 times. Then finally, when they separated, inmate Dale said, "I'm done." When Dale stopped, Mr. May stopped. They were arrested and escorted to the central unit. A hearing was held in the prison on November 15th, where Mr. May was found guilty of being involved in a fight pursuant to a KAR. On January 30th, 2013, Mr. May filed a petition pursuant to KSA 60-1501 and challenged the disciplinary rule violation for fighting. A hearing was held on April 3rd, 2013 in the Reno County District Court, and the court vacated the disciplinary conviction and granted Mr. May's petition. The respondent filed a motion to alter or amend on April 18, 2013. A hearing was held on that motion. The court denied respondent's request. A journal entry and order were prepared accordingly, and then the respondent filed a notice of appeal on June 21st, 2013. The Kansas Court of Appeals issued an unpublished opinion on April 25th, 2014. The court found that there was some evidence to support the hearing officer's initial determination that Mr. May was involved in a fight and reversed the district court's decision and remanded the case with instructions. What we're here for today is to determine 2 things: whether the Kansas Court of Appeals incorrectly applied the sum evidence standard needed to uphold the Kansas Department of Corrections hearings officer's determination that Mr. May was involved in a fight, and also the KER 44-12-12301 allows for self-defense. Thus, self-defense is not an affirmative defense.
Well, and on that second point, it strikes me that the crux of this case is a burden of proof question. The district court clearly held that it was the government's burden of proof to show to show that there was no self-defense, essentially. And the Court of Appeals held that the Department of Corrections was not obligated to disprove self-defense. Do you agree that that's the nut of this case?
Well, impartial, Your Honor. I believe that comes into play in the case. What's important to note is that in the KAR, it specifically states that fighting is not allowed, but it states at the end of it.
And you anticipate sort of the follow-up question, which is articulate for me why the government has the burden of proof in this case.
Well, it's not exactly shifting the burden of proof, but in the KAR, it says that fighting is allowed if it's in self-defense. And in this case, Mr. May asserted that. The district court just took that the fact that he asserted it, that there was evidence that he was acting in self-defense, that self-defense should have been brought up, but the hearing officer at the prison should have had at least gone through that and had taken that into consideration. As the hearing officer had found that Mr. May used that evidence that was presented to him and found that Mr. May was acting in self-defense, then he could not have been found guilty. I don't think it's a complete burden shift that the district court was doing. I think it was just saying that it never went through or did anything with the fact that he was acting in self-defense.
There's a burden of production as well as a burden of proof. And I think what you asserted just before my colleague's question was that the self-defense was the burden was inappropriately placed on your client, or it's not an affirmative defense. I mean, it is your client's responsibility to say, I was defending myself. That's
Yes.
a burden of production.
Yes.
But once he's testified, there's evidence. And your complaint really is that the hearing officer said there's no evidence of self-defense. When
Yeah.
in fact, there was evidence from your client. It may or
Yes.
may not have been believed, but it was evidence.
Yes.
So the burden of production has been met by your client. Then the question is, then where does the burden lie? Does it remain with your client, or does it shift to the state to dispute that evidence in some way? Isn't that really what you're saying?
Yes, I think in that, Your Honor, you're correct. It does shift back to them. Once the evidence presented, then the hearing officer would have to determine whether or not that was enough evidence to support the self-defense that he pled. And he pled that all along. Also, what comes into play here is the sum evidence, and that was important, and I wanted to point it out, that you can't just take away all the evidence and limit it down to what was stated in both the Anderson and McCune and Superintendent v. Hill. Both those cases had language that said any evidence in the record, and also it also characterized, although in this evidence it might be characterized as meager. Mr. May contends that that's just going way too far down on what needs to be presented at these type of hearings. We all know that prison's a very dangerous place. You and I can walk out of our houses and feel safe that when we walk out of our house we're not going to be attacked. But prisons are full of convicts. A lot of convicts who did bad acts. That's why there is that on the KAR where you can fight to defend yourself. Mr. May does not want to see the court make findings that a meager amount of evidence is enough to convict them. The respondent relied on the Miller case. In Miller, the evidence suggested that one inmate attacked another inmate for playing an appropriate movie. In that case, he came from behind and choked him. Miller at first admitted to being involved in the fight, but then at the hearing said that he only had struggled in self-defense and stated that at no point did he ever act as the aggressor. It should be noted that the only evidence presented in this case was the sworn statement of the reporting officer, and in the report was Mr. Miller's initial admission that being involved in the altercation and a statement that there was evidence to show Miller did attack the other inmate being choked. In Hill, a Massachusetts prison guard heard a commotion. He went to investigate and came across a prisoner who appeared to have just been beaten. Later, the prison medic stated that he believed the injuries were in fact the result of a beating, and in the distance the guard saw 3 other prisoners move quickly away from the area. When questioned, the injured inmate denied that anyone had beat him, and the other fleeing inmates when questioned, denied any involvement in any type of violence. In Mr. May's case, the key finding of the district court was there was no dispute that both men were fighting. There was no dispute that the other inmate had first attacked Mr. May. There was no dispute that the reporting officer opined that the other inmate appeared to be the primary aggressor. There was no dispute that once the other inmate stopped fighting, the respondent stopped also. And there is no dispute that the respondent claimed the right of self-defense. In applying the law, the district court said the hearing officer should have recognized that the respondent had the right to self-defense, unless shown by the preponderance of the evidence that the other inmate was not the aggressor. Likewise, as the petitioner failed to stop fighting when ordered to do so, the district court believed the government had to show that the respondent unreasonably continued fighting when he could have complied with the orders without the reasonable belief that if he stopped fighting, he would have received further blows from the inmate.
So you don't think that the CO standing there pepper spraying 3 times would have given your client reason to stop?
Well, Your Honor, in the instance when you're involved in a fight, especially a fight where somebody's, attacking you, if you stop fighting and the other inmate continues to fight, you're subjecting yourself to injury. More injury, you could get hurt more severely. So I don't believe in those circumstances that you should stop fighting. You should protect yourself, as they say in the ring, protect yourself at all times. And that's what Mr. May was doing. As soon as the other inmate stopped and got off and said, "I'm done," Mr. May stopped fighting also. The key distinction between these cases that in Miller Hill was there was some evidence, something tangible to point to. In Miller, it was the petitioner's own statement and the reporting officer's report to Miller attacking the other inmate after being choked. In Hill, it was the guard's observations. In this case, the tangible something does not exist, instead made a jump from observing the evidence presented to speculating about what evidence could possibly exist, and that's where the problem lies. In Mr. May's case, there's no dispute that he was involved in a physical altercation. There is, though, no evidence proving that he was fighting in anger or because of some dispute. That the evidence presented, though, does not show that he was a primary aggressor. It also shows that he stopped fighting when the attack ended. So it clearly, the district court reasoned that Mr. May was protecting himself, and then he was only acting in self-defense. Once the other inmate got off of him, he stopped fighting.
Counsel, I see you're out of time. Before you sit down, would you tell us what you're asking this court to do?
We're asking this court to reverse the Court of Appeals, uphold the district court's finding that Mr. May was not involved in a fight on that day in the prison. And we're also asking the court to, at least under the circumstances, the language of meager evidence be changed so the disciplinary officers at the prison understand that when they're reviewing this evidence, they have to take at least all the evidence into consideration.
And going back to the colloquy you had with my colleague a few minutes ago, my notes indicate that you had said the burden of production of some evidence of self-defense was on your client, but your client met that burden because he produced evidence that he indeed was acting in self-defense. Am I correct so far?
It's correct in part, Your Honor. He did present evidence that he was acting in self-defense. I don't think that evidence was ever gone into by the hearing officer.
Okay. And then you were asked by my colleague what happens after that, whose burden was it? And my notes indicate you believe the overall burden of proof, therefore, was on the state. Is that right?
Once he presented that he had evidence that he was defending himself, yes, I think then the state would have to prove that he was not defending himself. It's not like in a criminal case where you have to raise that affirmative defense, and then it's to the trier of the fact to determine whether or not you were acting in self-defense. This is included in the KAR itself, self-defense.
And what is the standard that the state would have to prove?
That he was not acting in self-defense at that time.
But by what amount of evidence?
By the same...
Beyond a reasonable doubt, or?
No, Your Honor. This is hearings that are conducted in a disciplinary setting within the prison walls. We understand that it's a lower standard, but they still have to take into account that there is evidence. Otherwise, anybody who's involved in a fight in the prison is automatically going to be found that they're guilty of fighting if they can't raise the fact that they were doing it in self-defense.
But what is that amount of proof that's necessary? You said it's not beyond a reasonable doubt. Is it a preponderance of the evidence? Or
I would believe it would be a preponderance of the evidence, the same standard that would be given to whether or not he was fighting.
All right, thank you.
Thank you.
Any further
Before you sit
questions?
down, I do have one more question. I want to again differentiate between burden of production and burden of proof, because I think they're different.
and one's greater than the other, and asking for too much may doom your case. Because to my way of thinking, what happened here was he was accused of fighting. The definition of fighting says that if you're acting in self-defense, you're not, by definition, fighting. You're defending yourself. So to the extent that's all he was doing, then he wasn't actually fighting under the regulation. Isn't that correct?
That would be correct.
So he came forward with evidence, says this was self-defense. At that point, the burden of production shifts to the institution or to the DOC. And the fact that they failed to come forward with any contrary evidence is where the case breaks down for the hearing officer who says there's no evidence to support his burden of production. Isn't that what happened here? I mean, we don't really even have to reach these questions of the quantum of proof or whether the state bears a burden of proof. It's burden of production, burden of going forward, as opposed to the ultimate burden of proof. Because the error that the district court identified in the hearing officer wasn't the error disregard of the evidence that had been produced to discharge the burden of production on self-defense?
Correct, Your Honor.
Okay, thank you.
Any more questions? Thank you, counsel.
May it please the court, my name is John Graves. I represent the state of Kansas, in this case Warden Klein, who was sued as a named party in the habeas corpus action.
And counsel, before you go on, I'll just jump right in here at the beginning and go back to this question of burden of proof. You would agree with me, I assume, that the state bears the burden of proof to establish the elements of the offense. Do you agree with that? Whatever those elements are, the burden is on the state to show that those elements have been met.
It's a peculiar animal, this disciplinary hearing. There is no prosecutor. The hearing officer receives statements from the different witnesses and reviews things, and then decides whether those things that are produced to him rise to the adequate level of proof.
And so if we assume that the burden is preponderance of the evidence, in order to sustain or reach a conviction of a certain offense under a KAR, the preponderance of the evidence has to be more likely than not that the elements have been met.
Yes, that's
Is that
part
a
of the
fair
regulation.
statement?
That's
And
part of
then we look to, in a criminal statute, we look to the statute to determine the elements. It would make sense to me, it seems, that in a regulation that defines an offense, we look to the language of the regulation to see what the elements are, right?
Yes.
And so that leads to my sort of what, again, I described as the nut of the case here. Why isn't the lack of self-defense, the absence of self-defense, actually an element of this offense? Because the KAR says fighting, et cetera, is prohibited unless such activity is in self-defense. And that strikes me as an element of the offense. It's right there in the definition.
Well, that was Judge McCarville's thought. And initially,
So what's the state's position with regard to that question?
I've thought about that at great length, trying to reason out how that is there and not some sort of an element. I guess in all battery cases, in all fighting cases, whether you're defending yourself or not plays a part of the decision whether you violated the
But it
rule.
plays a part it comes into play through a separate statutory provision, which permits the affirmative defense of self-defense, which can negate the elements. The lack of self-defense is not in the battery statute.
The administrative rules certainly are less extensive than the criminal law. That was mentioned in there to give, I suppose, to speculate, to give the hearing officer a reminder and an option, bearing in mind these are lay people that are conducting the hearings, that if the inmate acted in self-defense, that would be considered in whether or not he was fighting.
But the KAR could have, it's the Department of Corrections that writes the KARs.
Yes.
And the Department of Corrections could have written a separate KAR that mirrored the criminal statutes and permitted a inmate who was charged with this offense to raise as an affirmative defense that he was acting in self-defense. But that's not what happened. That's not what the KARs say.
Yeah, they could have done what you suggested, but they've also, the way they've done it now, it has about the same impact.
Well, but this case illustrates why it may not have the same impact, right? If it's in fact an element of the offense, the government would bear the burden to demonstrate that it's more likely than not that the person charged was not acting in self-defense.
Well, I would disagree with you to some extent, Judge. In the one case we have that appears to speak to this regulation is the Miller versus McCune case. It talks about the fact that, I cited that in my brief, of course, that talks about the fact that the question, if I could, on the last page of 816 of the decision, the question of self-defense was an issue before the hearing officer, but by the decision of guilty of fighting being reached, it is clear the existence of this defense was resolved against the inmate. I mean, it seems to me that we have a decision that's spot on.
And our Court of Appeals decision in this case basically just picks that language up and carries it forward.
I think so. Actually, this is a great case for this appellate court. You have an unlimited scope of review of the judge's decisions, the de novo review of issues of law. The facts are all in the record. All you decide, really, from the standard review is whether some evidence supports the decision.
Can we, counsel, here's what's bugging me.
Yes.
In the hearing officer's report, there in the last paragraph, it says that there's no evidence available to show that inmate May was simply defending himself. That's a quote. And that's not a true statement, just by looking at what the hearing officer reports up above. Can we agree that's not a true statement?
I don't know if he intended
that there is no evidence available that inmate May was simply defending himself. I mean, to begin with, he says he was defending himself. The guy may not believe it, but he could say, he testified, I don't believe him. He's not credible. But there is evidence that he defended himself, and so that seems to be wrong.
I didn't review the decision before it was issued, and I understand what you're saying. If you go through the whole decision, the judge starts out, or the hearing officer starts out by acknowledging that the reporting officer that was on the scene saw two men fighting. He, as was noted earlier, he asked him to quit, told him to quit. He sprayed him with chemicals 3 times before they quit. That's fighting. Now, everybody agrees that nobody saw how it started. There was no security camera, and that's the only challenge. I don't think that if we knew how it started, that still sustained the question of whether there was self-defense. Because at some point, what the judge got into that went completely outside the scope of review was to say, well, was it reasonable for him to keep fighting? And that's just not the scope of review. That may be something the hearing officer considers. But once the colloquy between the hearing officer and Mr. May was, Mr. May said, I was operating in self-defense. The hearing officer said, what can you show me to prove that you were operating in self-defense? Said, nothing. That was probably what the last comment in the decision was about, if you'd like me to speculate, Joe. But the fact is, when you go through the rules on self-defense, the burden on that can easily shift over to the defending party in criminal cases to establish that they were defending themselves, and that isn't unconstitutional to do that. It doesn't make me feel particularly comfortable, but it's not unconstitutional. But at this point in the process, you don't pick apart and reanalyze the whole hearing process conducted by a layperson with a limited record. You apply the Supreme Court standard, is there some evidence to support the conviction? If you want a little bit further guidance, then you look to the Miller case, which is Kansas Court of Appeals, to say the decision of self-defense was implicitly decided against Mr. May. It's an orderly process. It follows the proper standards of review. I understand what the court is saying, that it's something that was created by the regulation. It's been in place for decades, and it had never been brought up as being an issue before. I do truly believe that the point of the language being in there at all is to remind the hearing officer that self-defense ought to be considered. And if the inmate truly was put upon, truly was simply defending himself and not aggressively fighting, not continuing to fight, I think everybody would agree that you may have been defending yourself at some point, but if you keep fighting, that self-defense goes out the window. If an inmate goes into another inmate's cell, or the inmate is simply sleeping, and we had this happen, and attacks that inmate, and that inmate that was sleeping fights back, that's self-defense. However, if that inmate that's fighting back gets the guy down and keeps beating on him, that shifts from not being self-defense, or from being self-defense to being an aggressor.
Well, what's the evidence in this case that Mr. May was not acting in self-defense?
His continued fighting, his ignoring the officer's instructions to quit.
Well, my understanding is that, but correct me if I'm wrong, is that he was essentially, I'll use the phrase, being pummeled. He was losing the fight, as it were, and that the officer had to spray the aggressor and spoke specifically to the aggressor, not to Mr. May. And it was the aggressor who then, after being sprayed, said, "I'm done." Am I missing anything from the
Mr.
undisputed
Dale
facts?
said, "I'm done." But before that, they were continuing to fight.
But the
And you can-
report indicates that Mr. Dale was winning, my language, winning the fight, and that the spraying happened to Mr. Dale. I mean, that's how I read that report. Am I wrong?
I don't see my recollection is not that there was ever a pronouncement of who got more points in the fight. I think it was a mutual combat until they stopped. But Mr. Dale was a younger guy, and Mr. May was older than he was.
So is there any evidence that you can point to other than the fact that the altercation was ongoing to show that Mr. May was not acting in self-defense?
Well, without repeating what I've already said, I mean, he didn't stop when he was given the opportunity to. Even if he was defending himself at some point, he could have quit, and he didn't. And by my way of thinking, trying to apply the correct standards, I think that means that if he was defending himself at some point, he stopped and he became a fighter. If he wasn't a very good fighter, that's on him to deal with. That's my response, Judge.
So even if the other combatant was continuing to fight, in order to avoid a disciplinary infraction for fighting, Mr. May had to stop and let that inmate continue to hit him because there'd been an order to stop? Is that your position?
It's a difficult thing to talk about.
Is there anything, would you agree with me that that's your position on what occurred after the order to stop?
Judge, yes.
Okay,
In a
so
nutshell.
regardless of whether he was defending himself before that point, you're saying he's still guilty of fighting for failing to stop when given an order to do so, regardless of whether he's being beaten up by somebody?
In my opinion, Judge.
Okay.
But to carry that one step further, the standard at this point isn't going back and applying a preponderance standard. It's seeing if there's some evidence.
Some
keep
evidence, and
coming
that would
back
be the
to that.
some evidence in your view, is that he failed to stop after being ordered to do so, regardless of what the other inmate was doing.
Quite simply, some evidence is Mr. May's admission, I was fighting. That's some evidence. The officer's observations,
Well, the officer observed inmate continued wrestling where, from my advantage, Dale was the aggressor.
yes, sir.
If Dale's the aggressor, what does that make Mr. May?
He shouldn't have been involved in the fight.
Well, are you saying they both were aggressors, or one was an aggressor and one was a defender?
I'll share with you kind of the approach that has been shared with me over the years, that if you are simply protecting yourself, trying to avoid blows or not advancing a fight, but simply trying to cover up and prevent injury until you can be separated. And the reality is, in prison, most of the time there's officers close by that do separate fights out. Then you are defending yourself. But if you become actively involved in the fight, throwing blows, throwing kicks, trying to choke somebody, whatever that fight be, the self-defense is somewhere behind you. you've become a part of the problem. You've become part of the fight.
Well, that's not
So-
true. Sorry, go
I
ahead.
was gonna say, so to use a historical example, if you're familiar with the rope-a-dope tactics of Muhammad Ali, that is what the inmate who thinks he's being aggressed against has to do. He covers up and absorbs the blows, and when he moves from that position and puts his fists up and actually throws a blow himself, then you're into fighting, and self-defense has gone out the window.
Well, at the very least, you've now created evidence of a fight. In the example that I gave about being in a cell and having another inmate come in and attack you, that might be a bit different.
But is
At
that,
some point, even though you've balled up your fist and you've thrown a punch, but you're doing it to try to protect yourself, you've just gotten up out of a sleep, and you have to, your reaction is do something. But when you continue to fight and you continue to push the fight, I think things can easily shift. But I still come back to the some evidence issue. I'm sorry, Judge.
is that consistent with this regulation? I mean, the regulations in terms of fighting, I mean, the way I understand what you're saying is you basically have to go into, some sort of a defensive position and not strike a blow. Well, that would never, why would that ever be considered fighting? The regulation seems to take something that we would normally consider fighting out of that realm because it is in self-defense. So I'm not understanding your explanation.
Well, I was asked I tried to put it into the context of how things are viewed in the prison system. People, battery is a rude or insolent touching of another in a normal setting. In a prison setting, there's a lot of interactions that are different than you would expect on the street. We ask that the inmates not, if they want to take advantage of the self-defense, that they don't fight.
But
Once they
that's-
start throwing, I'm sorry, Judge.
Well, go ahead, I'm sorry.
Your question, your point is accurate. I don't disagree with what you're saying. It doesn't seem totally fair that you should have to simply protect yourself, and the rope-a-dope example is perfect. That's you do that, you're not going to be charged with fighting,
Why do you need the regulation then?
ma'am.
Why do you need that statement in the regulation then?
Well, I
Because
guess that's a
the regulation starts with the premise that you are fighting,
yes.
and then it excuses the fighting because you are acting in self-defense.
Yes,
And what I hear you describing is you're not fighting, you're just taking defensive action postures.
Yeah, I think as I commented earlier, if it's been in there for a long time, I think that it is in there in part to remind the hearing officer that self-defense is something to be considered. But I've been in the system over 20 years, and it's just never come up as an issue of an element before. So I don't disagree with the fact that you 7 justices can decide that that's what it is, and it becomes an element that needs to now be addressed in a different way. But to this point, it never has been. And the hearing officers, who are lay people, are really put at a gross disadvantage of trying to imagine what a judge, in this case our trial judge, decided they should have done in a hearing conducted many months before that. I come back to this, although I understand the point about self-defense as an issue. I think your Court of Appeals case says that it was considered and implicitly rejected. I think the standard put in place by the Supreme Court is that you find some evidence to support the conviction, and you affirm the Court of Appeals in this case.
Justice Stegall, you had a question several minutes ago. Do you still
No more,
have?
thank you, Chief.
Any further presentation?
I don't think so, Judge.
Any more questions? Thank you, counsel.
Thank you very much.
You reserve 5 minutes for rebuttal.
Thank you, Your Honor. Pleases the court. I think the questions that the court was asking are appropriate questions in this case.
Well, let me ask you then, why isn't that when the guard came on the scene and told them to cease fighting and the fight continued, that the self-defense goes away? He has the officer there to help protect, separate the combatants. Why isn't that some evidence of fighting, self-defense? I appreciate the adrenaline flow that probably is happening there. It's hard just to stop when you're told to stop, but why isn't that some evidence that the fight continued? And that's where the self-defense ended?
I don't think that you could say specifically, and it would actually be on a case-by-case basis. In this case, if the aggressor's on top, he's pummeling, and you're just trying, and we don't know, there's not enough evidence that's in there that says, we don't know what Mr. May was doing, if he was throwing punches, if he was kicking, if he was doing anything, or if he was just maybe swinging his arms, preventing blows from getting down upon him. But it's clear that there is a self-defense portion to this KAR. And if Mr. May's
It's clear after they were told to stop that there's still self-defense. That's my question.
Judge, sometimes you can't stop in a certain
That was my point.
Yeah, and if it's a prison setting, you don't know what the other guy's going to do to you. You don't know if he has something on him that could hurt you even more if you stop. So you continue until the combatants are broke apart. I know that the officers have to follow certain things to break them apart. He sounded like he was doing this protocol in this place. The first thing is to announce, break up the fight. And the next thing would be to...
So your position is you're not, the record doesn't say whether or not it's just the aggressor continuing to pummel your client after they're being told to stop, or your client was actually engaged in some sort of mutual combat or something.
Well, I think there was some evidence that was shown that he didn't stop. What that was, we don't know.
Who didn't stop?
That Mr. May didn't stop. But it's clear that once Mr. Dale stopped, Mr. May stopped. And it was clear that from what the corrections officer said, that Mr. Dale was the aggressor. Mr. May was getting, like the justice said, the best of it. And, in circumstances like this, I think that's why they put that in there. Because otherwise, why even have self-defense in there? That's the whole point. Is if you're not going to be allowed to defend yourself, and Mr. Graves is stating his example is when somebody goes into a cell and attacks somebody, that you can defend yourself. Well, if somebody attacks you in the yard, you have the same right to defend yourself. So it doesn't matter where it happens or how it happens. The matter is that there's self-defense. And self-defense, to me, means that you protect yourself at all costs until the separation. And that's what the Chief Justice's rope-a-dope's great. Muhammad Ali, great fighter. Rope-a-dope's great. But Muhammad Ali used that as a tactic. When they wore themselves out, Muhammad Ali pummeled them. In this case, Mr. May was just defending himself. You can't just sit down there and cover yourself up because you don't know what's going to happen to you. If there were more officers on the scene, if they were being separated, if there was something and Mr. May's throwing punches back at him as they're being separated, yes, maybe. But in this case, fighting is not allowed unless in self-defense. Why put that language at the end of that, KAR? And so it's our contention that Mr. May presented enough evidence for at least the hearing officer should have taken it into consideration. The case that Mr. Graves cites, in that case, it was totally after the fact that Mr. Miller ended up in an altercation with another inmate after something had happened, and he admitted that he was fighting. In this case, Mr. May says, I was defending myself. That it wasn't fully explored by the hearing officer is the problem that is a major problem with this case. It should have been at least addressed, not just like the Court of Appeal said, it was decided by the hearing officer. It should have been addressed further and deeper, and that's our contention.
Mr. Graves said that Mr. Mays was asked, what can you show me? What else do you have to show self-defense? And he said nothing. What else would the officer have done beyond that?
Well, you're talking about a prisoner who's got no legal training at all. He could have been able to say, well, yes, you do have evidence. He could have said that, but he has no legal training at all. He's put in a position, at that point in time, he's probably saying, well, I'm just going to be found guilty, so why don't you just do what you're going to do? But there was evidence, Your Honor. I contend that there always was evidence that he was acting in self-defense.
Any further questions? I see none. Thank you, counsel.
Thank you, Mayor.
I thank you both for your arguments this morning. The court will take this matter under advisement. That concludes